We are live. We are live.
Professor, I think you have to admit the participants. Good evening, everyone. If you could please post into the chat your time splits for this round. Okay. All right. And in the event of any internet outage or needing to get a hold of me, I have put my cell phone number in the chat before we begin. Now, if everyone for participants would please close your chat windows. We will begin here momentarily. Oyez, oyez, oyez. All those having business before this honorable court draw near and they shall be heard. The Honorable Judges Mohapatra and Anawis with Chief Justice Hamilton presiding. God save the United States and this honorable court.
Good afternoon, everyone. We'll be hearing the case of Karen Smith against Hamilton Heights Veterans Home in the state of Lincoln, number 20-1964. Could I ask all counsel to just at least give us a visual thumbs up if you can hear us all right? All right, excellent. And we'll hear first from counsel for petitioner, and will that be Mr. Dernbach first? Or sorry, Mr. Fishman first, is that right?
Correct,
All
Your
right,
Honor.
please go ahead at when we're ready for you.
Good afternoon, Your Honors, and may it please the court. My name is Micah Fishman, and along with my co-counsel, Michelle Ocasio, we represent the petitioner, Ms. Karen Smith, in this matter. I will explain how Governor Wu's executive order is an invalid exercise of police power and violative of the 14th Amendment. And my co-counsel will explain how the respondents were required to provide reasonable accommodations to Ms. Smith under the Americans with Disabilities Act. I'd like to reserve 2 minutes for rebuttal.
Right.
This case presents a grave concern for the protection of individual liberties under our Constitution because even in times of crisis, government authority is never complete. This court cannot allow a governor to abuse her power during the coronavirus pandemic and enact a law that is both unreasonable and arbitrary at the expense of citizens' constitutional rights. We ask this court to affirm the lower court's decision for 2 reasons. First, the order has neither real or substantial relation to the ongoing threat to the state of Lincoln. And secondly, the order is a plain, palpable invasion of rights secured by the Constitution.
Which rights are those, Mr. Fishman?
The rights alleged here are going to be violations of the Equal Protection Clause, and there are some substantive due process arguments.
The equal protection, I think I understand. The substantive due process, I have a little more trouble with, but please proceed as you wish.
Thank you, Your Honor. Turning to my first point, the executive order does not satisfy the first prong of the Jacobson analysis because it is not responsive to the pandemic threat in the state of Lincoln. Even the Supreme Court over 100 years ago in Jacobson versus Massachusetts rejected the notion of a blank slate upon which the government could enact any type of emergency law it saw necessary. The mask mandate in Section 2A of Governor Wu's executive order only at best marginally meets the purported goals of the mandate and public safety requirements because there is no threat to the state of Lincoln. This court has previously recognized—
Is it your theory that the order was just too early? She should have waited until more people got sick and died in Lincoln?
Correct, Your Honor. The timing is just one
Should have
instance in which.
waited? Is that right? She should have just waited until more people died before asking or telling people they had to wear masks? Is that the position?
She should not have waited until more people died, per se, Your Honor. However, the timing of the enacted order is suspect because she enacted an oppressive mask mandate after the date of the last transmission of the coronavirus within the state of Lincoln.
But haven't we seen, Mr. Fishman, that the way that coronavirus and COVID-19, it kind of, ebbs and flows. And so even places where there were low cases, there's now high cases. So isn't this a prudent decision, or at least within the realm that Jacobson allows?
It's possibly within the realm of what Jacobson allows. However, the reason why it doesn't satisfy the real and substantial relation standard is because it doesn't take into consideration the facts on the ground. And I'd like to address Your Honor's question in two parts. The first of which being, this ordinance is not valid. The executive order is not valid because although the purported goals of saving lives and keeping the citizens of Lincoln healthy are in fact legitimate, this court has recognized before that where a purported goal is only served marginally at best by an executive order, the court should strike that order down as unconstitutional. That was promulgated in Moore versus the city of East Cleveland, where an ordinance categorizing and criminalizing a second grandchild living in the appellant's home was illegal, was still struck down even though the city's goals of reducing overcrowding, minimizing traffic, and avoiding an undue financial burden were legitimate. And it still didn't.
Do you think trying to control family relationships, which was really the core of Moore, is really comparable to trying to protect public health from an unprecedented emergency?
No, Your Honor, the goals are not comparable, but what is comparable is the holding. The holding in Moore is analogous to this case because both of the purported goals, albeit the purported goals in the state of Lincoln present much more dire circumstances. The mask mandate in Section 2A only marginally meets the goal because there is no active threat within the state of Lincoln. And the order is overly broad because it is not responsive to the situation on the ground. There are no active cases within the state of Lincoln. There hasn't been a transmission since April 23rd, and the order was enacted after the date of the last transmission, all as indicated by the 12th Circuit and the District Court, beginning on page 4 and continuing through page 5 of the record. There are still going to be uncertainties.
Can I ask you, have we, you say the holding of Moore applies. Of course, precedent can be kind of plastic. And I'm wondering, have we ever struck down a public health measure on equal protection grounds?
Your Honor, I'm not exactly sure if this court has ever struck down this type of measure in response.
I'm not aware of any. I'm not aware of any.
I'm not either. The only similar case before this court was heard in May 2020, where the concurring opinion of Chief Justice Roberts was published in South Bay United Pentecostal Church versus Newsom. However, that challenge was on a First Amendment basis and not an equal protection clause analysis. So the reason,
do you think you've got a stronger case on an equal protection theory than in a free exercise of religion ground?
Your Honor, there is no indication that the cause of action here is anything implicating the First Amendment. And that is the precise reason why Jacobson presents such a unique challenge. As I will address in my second point, that is where the 14th Amendment's equal protection clause is implicated here. However, Jacobson is distinguishable from this case because the vaccine mandate to slow the spread of smallpox within the state of Massachusetts was necessary to cure the disease. And here, the mask mandate is simply one way to slow the spread of coronavirus, but taken in conjunction with other measures, then it becomes more effective. And the effectiveness of these measures changes seemingly almost daily, and the studies of the effectiveness and the best way to cure the spread of COVID-19 are within its infancy. And
right.
Returning.
So let's follow up on that, because it's one of the points that the Chief Justice Roberts raised in the South Bay concurrence, and that's bubbled up in lots of the other litigation involving responses to COVID. And it really has to do with uncertainty and risk. You're certainly correct that things are changing quickly. Science is changing. And the question really is, what role do courts have? We're usually not very nimble in responding to crises or changing facts and changing science. Why shouldn't we simply defer in all but the most outrageous and discriminatory cases to the elected officials who have primary responsibility here?
Your Honor, you're correct in noting that normally courts are going to grant deference to the people best suited to handle the situation on the ground. However, the governor has the unique ability through the Emergency Management Act listed on page 6 of the record to act quickly through the executive order. So unlike the legislative branch of the government, which represents the people, ordinarily that is going to be a slow process. So what should have happened here is the governor could have seen that the facts on the ground indicated that there was no true threat to the state of Lincoln at the time that this litigation was filed. So instead of enacting an order that was responsive to the situation on the ground and maybe just included measures and orders including social distancing and hand washing, she enacted an oppressive order. However, the facts do change on the ground daily. And as we've seen anecdotally, the island nations like Australia and New Zealand at first seemingly suppressed their instances of COVID, but there has been a resurgence. So the unique position that the governor is in gives her the ability to respond quickly and swiftly if there were to be a resurgence.
I would have thought that the resurgences that we've seen in New Zealand and Australia are pretty strong reasons for upholding the governor's order here.
Well, that is the precise question that this court is called upon to answer, because it does trample all over the petitioner's constitutional rights. And another reason—
Sorry, wait a minute. Trampling over constitutional rights is a phrase I may hear a lot, but she's not been singled out for any unique discrimination. Everybody is confronting difficulties with these kinds of measures. What rights are being trampled here?
Well, Your Honor, the primary right being stepped upon here is her right to be free from being arbitrarily discriminated against by the government, which would lead me to my—
That's just second guessing the governor's judgment about needed health measures, right? That just takes us back into the equal protection analysis under rational relation review, which is as deferential as it gets. And we've agreed, I thought, we've never struck down public health measures on this basis.
Well, Your Honor, today we're asking this court to strike down the ordinance on equal protection grounds because the order is wholly arbitrary, which would bring me to my second point, where Governor Wu's executive order is a plain and palpable invasion of rights secured by the 14th Amendment because it arbitrarily discriminates against Ms. Smith. So the second prong of the Jacobson analysis speaks directly to the equal protection clause, because we're looking at whether or not an order is arbitrary because it treats nursing home workers differently with no sufficient justification from those in similarly situated facilities like prisons and hospitals.
If the executive order allowed exceptions for nursing homes, would it be okay then?
Potentially, Your Honor, but that would present a different question for this court to call upon. If it treated other similarly situated individuals differently, we might not be here today. But the reason—
when you were talking about the fact that, Jacobson allowed vaccinations, but this is much more oppressive, aren't masks less invasive than vaccinations? I mean, what's wrong with just wearing your mask?
As applied specifically to the petitioner, this case presents the problem that it would inflict injury upon her because she has an ADA recognized disability, which my co-counsel will explain in her portion of this problem. So the real issue is here that a facially neutral ordinance can still be discriminatory in its application. And this idea was first set forth in an unlikely zoning law case named Village of Euclid versus Ambler Realty, where a zoning law upholding the constitutionality of a city zoning ordinance could be found constitutional as applied to a large urban center with a high population, but the exact same ordinance could be found unconstitutional as applied to a rural urban community. So here, Governor Wu's order is arbitrary and violates the 14th Amendment because it was enacted without any consideration for the facts on the ground and circumstances applicable to the state of Lincoln. The citizens of Lincoln, additionally, are not similarly situated to other citizens within the United States due to them living on an island state, which speaks more to this Euclid analysis.
But it sounds to me, Mr. Fishman, that you're arguing that in essence, the Equal Protection Clause entitles either your client or the citizens of Lincoln to special treatment. Is that right?
No, Your Honor. The Equal Protection Clause does not require that each person be dealt with identically, but rather there be some rational basis for the distinctions made. And here, the proffered reasons for any distinctions made are completely arbitrary in that there is no sufficient justification for why the governor treated nursing home workers differently. There are vulnerable populations all throughout the state of Lincoln,
Is there any
including
population more vulnerable than nursing home patients?
potentially not, Your Honor, but that is not the de facto reason and determining factor as to why the other populations are not deserving of protection. People within prisons and hospitals are living in congregate facilities where social distancing measures are impracticable.
If that's correct, then the remedy should be not to strike down the application of the executive order as applied to your client, but to order the governor to impose those restrictions in prisons and hospitals more broadly?
I see my time has expired, Your Honor.
Please go ahead and respond.
If the executive order was different in its text and provided exceptions for similarly situated individuals, it is likely that the petitioner would not have a claim here. Thank you.
Okay, thank you very much. We'll next hear, is it from Ms. Locascio?
Yes, Your Honor.
All right, good afternoon. Go ahead.
Thank you. Good afternoon, Your Honors, and may it please the court. My name is Michelle Locascio, and I also represent the petitioner in this matter, Ms. Karen Smith. Your Honors, this case involves a dedicated janitor who is merely seeking accommodation to wearing a mask due to her claustrophobia during times of significant uncertainty. Although we are living amid a pandemic, the CDC expressly recognizes that wearing a face covering may not be possible for all individuals, especially when doing so may exacerbate a mental health condition. In line with the ADA, the CDC recommends considering adaptations and alternatives to wearing a mask whenever possible. The same should be true here. Hamilton Heights violated the ADA by discharging Ms. Smith from her janitorial position without considering possible accommodations. Thus, this court should reverse the lower court's decision for two reasons. First, Ms. Smith has a disability under the ADA. And second, Ms. Smith is a qualified individual under the ADA because she can perform the essential functions of her janitorial position with reasonable accommodation. Turning to my first point, because Hamilton Heights has already conceded that Ms. Smith's claustrophobia constitutes an impairment under the ADA, as indicated on page 14 of the record, the heart of this court's analysis should focus on how Ms. Smith's claustrophobia substantially limits her major life activities, including her breathing, thinking, concentrating, interacting with others, and working. As the EEOC in their interpretive guidance to the ADA states, an impairment is substantially limiting if it limits the ability of an individual to perform a major life activity as compared to most people in the general population.
Ms. Locascio,
However,
Ms. Locascio, how much weight should we give to the EEOC guidance?
Your Honor, the EEOC guidance gives us guidelines on what a court should consider. However, it is not precedential, but it is important to note that the Congress amended the ADA in 2008 explicitly to reinstate the broad scope of protection that was effectively eliminated by this court through several Supreme Court decisions that narrowly construed the term disability and what could constitute a disability under the law. And here, where the Supreme Court previously held that an impairment had to significantly or severely restrict a major life activity, that is no longer the case, and instead, this is a low bar to surpass. And here, Ms. Smith has offered sufficient evidence demonstrating that her claustrophobia substantially limits all of her major life activities in which she is asserted on the record. She specifically states that she feels trapped such that she needs to escape, and that subsequently triggers panic out of fear that she will suffocate, as indicated on page 7 of the record. And she furthermore—
Ms. Locascio, could I ask you, I think we can all appreciate, at least to some degree, her difficulties. I would have thought that you face some more difficult problems on your ADA claim, just from the fact that you seem to be asking the employer to violate the governor's executive order in order to accommodate your client. Is that right?
Your Honor, petitioner here is asking Hamilton Heights to reasonably accommodate her for her disability, which is part of the interactive process under the ADA.
I understand that, and we can talk about the interactive process, but the accommodation that you're proposing would violate the executive order, correct?
Your Honor, the executive order specifically states that that nursing home staff must wear something that covers their face and their mouth, and it lists examples that can be utilized. However, it does not limit those examples to a face mask, and one of the proposed accommodations that petitioner has here set forth on the record, including a face shield, is something that falls within that definition in the executive order and should be a proposed accommodation that Hamilton Heights should have taken into account during the interactive process to find that she could continue in her gainful employment as the ADA protects.
Ms. Locascio, what should we do with the evidence or guidance from the CDC that face masks are more effective than face shields and that face shields are not as effective? What do we do with that?
Your Honor, it is important to note that the CDC does not know the efficacy of a face shield as compared to a face mask. And that may be true during these circumstances when the COVID-19 pandemic is ever changing and circumstances are changing on the daily. However, with all of the accommodations that Ms. Smith has here proposed, which are actually 6, including the face shield, as Your Honor noted, and also social distancing, hand washing, temperature checks, and routine testing and screening of the facility employees should, taken together, be enough to allow Ms. Smith to continue her gainful employment such that all of these accommodations together are reasonable. While a face shield on its own may not be reasonable in this situation, with these other accommodations, they would be. And in fact, this takes me to the social distancing, which should be something that Hamilton Heights should have taken into account, because it is important to note that janitors, like Ms. Smith here, does not participate in patient care or assist residents with bathing, nutrition, or medication administration. And she similarly does not engage in interactions with nursing home residents, which would typically require the intimate proximity of that of a nurse. Ms. Smith could reasonably avoid encounters with the vulnerable residents at Hamilton Heights by cleaning their rooms while they are in common areas or vice versa.
No, go ahead.
So right now, during the pandemic, many nursing homes have social distancing restrictions where you can't go and gather in a common area. So is the ability to perform the job during a pandemic an essential function of being a custodian in a nursing home when you're working with such vulnerable populations?
Yes, Your Honor, it is an essential function, and we do not dispute that she can perform all the essential functions of her job in this case, other than adhering to the face mask requirement. But given that the nursing home is home to over 300 individuals, and that this is likely a big building, and the record is silent as to the dimensions or the square feet of which this building is, it is reasonable to assume that there are other janitors that Hamilton Heights employs that, as Your Honor mentioned, could possibly go into someone's room without wearing a face mask, and thus allow Ms. Smith to continue her employment, and so that she does not have to be terminated from this position and from this job that she has held for the last 4 years. And in fact, this case is very similar to Sperling versus C&M Fine Pack Incorporated, where the Seventh Circuit found that an employer failed to engage in the interactive process after the plaintiff provided an ADA form identifying a disability. There, the employer did not collaborate with the plaintiff or her doctor to find any reasonable accommodation. The employer did not seek further clarification from either the plaintiff or her doctor, such that they did not inquire as to the severity of plaintiff's disability or how it might be able.
Excuse me, but is it your theory that the employer violates the ADA simply by failing to participate in the interactive process?
Failure, Your Honor, failure to participate in the interactive process is not an independent basis for liability for the employer. However, when the failure to engage in the interactive process leads to the failure of identifying possible accommodations in which the employer could have imposed, as indicated by Sperling in the Seventh Circuit, that is where the employer can be liable under the ADA. And that is why Hamilton Heights should be liable here.
I'm always happy to entertain arguments that the Supreme Court ought to be following the Seventh Circuit's precedent. But let me tell you what really troubles me most about your case, and that is there's a line of cases, Ms. Locascio, under the ADA involving employees who are caregivers, who are responsible for the safety of others, doctors, police officers, people who work in transportation, who may be driving trucks, driving trains, flying airplanes, and so on, where other people's safety is in their hands. And the ADA, it seems to me, poses some really special challenges for people like that. And that would include nursing home workers at this point in the pandemic, particularly looking at what I think everyone agrees is a high degree of uncertainty about how effective different measures are in protecting vulnerable populations. Face shield, face mask, with or without social distancing. Nobody's really sure how effective these are in quantitative terms. And we've got an incredibly vulnerable population here. Why you seem to be asking us to interpret the Americans with Disabilities Act so as to give your client the right to demand that others accept risks for her sake. Is that right?
No, Your Honor, we acknowledge that Ms. Smith could possibly pose a risk to the vulnerable residents of Hamilton Heights, and that is of great concern to us. However, it is also a concern that Ms. Smith is an employee and she has a disability, and she's wanting to find the protections of the ADA, which should be afforded to her broadly as indicated by Congress. And as Your Honor mentioned, janitors perhaps may be possible for caring for individuals, but as previously stated, a janitor does not have the same responsibilities of that of a nurse that would be within Hamilton Heights and would be within the intimate proximity of the vulnerable residents here. And of the proposed accommodations that Ms. Smith has set forth on the record, going forth from where I left off, including the hand washing and the temperature checks and routine testing and screening of facility employees, all taken together would be a reasonable method to prevent against the spread of COVID-19.
Why do you say that? How do we know that?
Your Honor, that is the question we're here to answer.
Well, that's the question. And for your client, it's this job. Maybe she could transfer to another job at Hamilton Heights. I don't know. But it's also life and death for the patients in Hamilton Heights. How do we deal with that?
Absolutely, Your Honor. It can be life and death for the vulnerable residents at Hamilton Heights. But when we also consider the low incidence of COVID-19 in the island state of Lincoln, and the fact that Ms. Smith takes her own precautions because she lives alone and she avoids areas where she cannot social distance, as indicated on page 9 of the record, and going back to the last transmission of COVID-19 in the island state of Lincoln, which was on April 23rd, 2020, as indicated on page 5 of the record, that taken together with the accommodations she has proposed should be at least sufficient to mitigate against the risk that she poses to the vulnerable residents at Hamilton Heights.
Counsel, indeed, isn't the risk low because of measures to protect people, such as masks and hand washings? And additionally, there are people who are asymptomatic in the community that we believe, or the CDC tells us, could be vectors of transmission. Does this not pose an unreasonable risk to the people in the nursing home who have high risk factors for acquiring COVID-19?
Your Honor, if petitioner engages in hand washing and engages in the screening and temperature checks and wears a face shield and engages in social distancing, altogether, while all those things on their own may not be effective against the spread of COVID-19, taken together, they would be effective in this instance. And it is important to note that the primary purpose of the ADA is to make it easier for people with disabilities to obtain protection under the law. By requiring reasonable accommodation, Congress intended simply that disabled persons have the same opportunities available to them as are available to non-disabled persons. To allow Hamilton Heights to discriminatorily fire Ms. Smith from her janitorial position without consideration, I see my time has expired. Thank you.
All right, thank you, Ms. Locascio. Let's see, we'll next hear from counsel for respondent. Will that be Mr. Dernbach first?
Yes, Your Honor.
Okay, go ahead.
Chief Justice, and may it please the court. My name is Chris Dernbach, and I, together with my co-counsel, Lauren Kauser, represent the respondents and cross petitioners, Hamilton Heights Veterans Home and the state of Lincoln. The first issue before this court concerns the 12th Circuit's decision that Executive Order 2020-16 is not a valid exercise of the state of Lincoln's police powers under Jacobson versus Massachusetts. That decision should be reversed for the following 3 reasons. First, Executive Order 2020-16 is substantially related to protecting the public health from COVID-19. Second, the order is not arbitrary, but rather draws reasoned distinctions between nursing homes and other public establishments. And third, this court's precedent routinely instructs that the state is in the best position to make decisions regarding public health and should be given due deference. In 1905, this court in Jacobson versus Massachusetts held that the judiciary should only interfere with the decisions of state and local governments regarding public health where those decisions do not bear a substantial relation to that objective or where they are beyond all question a plain, palpable invasion of fundamental rights. And the logic of this court in Jacobson rested on the idea that the judiciary should not second guess the decisions made by state and local governments in dealing with public health care.
So are you saying, sorry.
Go ahead.
Mr. Dernbach, so do you acknowledge though that Jacobson places some limitations on how far a state can go in the name of public health, and that courts really have an obligation to kind of make sure that the state isn't unduly, infringing on citizens' rights? Yes,
Your Honor. Of course, the state must be stopped at a certain point. However, that point is not reached here. The Executive Order 2020-16 is in full compliance with the Jacobson framework because it is both substantially related to protecting public health in Lincoln and because the order is not arbitrary, therefore not a substantial violation of fundamental rights. And Your Honor, I believe you also had a question.
Well, I was just observing that Jacobson was highly deferential to public health measures at a time when this court was not at all deferential towards state and local governments, for example, with respect to economic regulations. wage and hour laws, for example, which I guess raises the more general point. Doesn't Jacobson need the Jacobson framework need a little updating more than 100 years after, and with all of the evolution of constitutional law and doctrine that we've seen since then?
No, Your Honor. Jacobson does not need to be updated because the standard it sets forth is based on the idea that judges must not second guess the decisions of state and local governments where those decisions do not offend the Constitution. The Jacobson—
Well, that's kind of circular, all right? Okay. The question is, what does offend the Constitution? And we have Jacobson telling us if it's arbitrary or oppressive, which doesn't tell us a whole lot. Do you think it's reasonable for us to kind of reflect back and impose the rational relation test that we apply on equal protection cases to public health matters like Jacobson or this case?
Your Honor, even if the court did apply a rational basis review to this case, the order would still stand because it is rationally related to the valid governmental objective of protecting the public health. The governor accepted guidance from the Center for Disease Control, stating that wearing masks in public places can help to prevent the spread of the disease through respiratory droplets. She looked to guidance from other jurisdictions where in states in our nation and nations abroad that implemented public mask wearing mandates. In fact, in Jacobson itself, this court recognized that a common belief in the efficacy of vaccinations and their use in other jurisdictions showed that the vaccination mandate in Cambridge was substantially related to protecting the public health. And here we have the same case. The governor was aware of the fact that other jurisdictions had implemented similar mask mandates. And that shows that the order is substantially related to protecting the public health. And as to Section 2A of the order, which applies a more protective approach in the context of nursing homes, by not allowing exceptions to the mask mandate, the governor likewise had substantial reasons for doing so. As opposing counsel admitted, there is no context as vulnerable as nursing homes. That alone is a reason to uphold this mandate because it shows that nursing homes need to be treated more protectively than other types of public establishments. They have higher risks than other types of public establishments. For instance, the Center for Disease Control has issued guidance that persons who are over the age of 65 years old present heightened risks of severe complications and death from COVID-19.
So there's also emerging data with respect to extra vulnerability for certain racial and ethnic groups, correct?
Yes, Your Honor.
Okay, so how far does this go? Would the government, let's imagine Lincoln has spreading infections, and a governor decides that a particular racial or ethnic group that is especially vulnerable ought to be housed in special camps or housing complexes so they can be protected. What do you think about that?
Your Honor, that would certainly fail because a case such as that one would be analyzed under heightened standards of scrutiny that this court has held apply in the context of racial or ethnic discrimination. Here,
but the argument would simply be based on medical grounds.
No, Your Honor, because
I can imagine the tweets from the executive mansion now justifying this this segregation. Should we allow those?
No, Your Honor. Under the second prong of Jacobson, the case must also not be a plain, palpable invasion of fundamental rights. That would require this court, in a hypothetical such as the one you posed, to analyze whether or not the the mandate in that case was a valid exercise of the state's police powers under the Equal Protection Clause. And it would not be because of the fact that racial discrimination or ethnic discrimination is subject to a heightened standard of scrutiny. But those heightened standards simply do not apply here. The petitioner has not claimed that there's any suspect classification or fundamental right implicated in this case. And therefore, the court would analyze this under the simple and deferential standard of rational basis review and ask if the governor had any plausible policy reason for implementing Executive Order 2020-16.
So, Mr. Dernbach, this court in the last several years has seen some rather extraordinary attempts by an executive to use emergency powers. And one of the arguments that we're looking at here, I guess, we're being told by your colleagues on the other side that this order is really not necessary. At best, it's way premature. So presumably, one can find some threatening infectious disease somewhere in a world linked by international air travel at any time. And if the governor's emergency powers allow her to take extraordinary measures in response to an impending risk, what limits are there? Don't we have to go ahead and look at how serious and how imminent the risk is? And it doesn't look very imminent in Lincoln right now.
Your Honor, in the state of Lincoln, there is an imminent risk of spread from COVID-19. First, we know that COVID-19 is a rapidly evolving and fast spreading respiratory disease. Second, we know that there are asymptomatic carriers who can carry the disease and spread it to others without showing any symptoms whatsoever. And therefore, those persons would be very unlikely to have been tested for COVID-19 and then to quarantine themselves. And furthermore, particularly in the context of nursing homes, we know that persons in those facilities are above the age where science tells us they'll be immunocompromised and that heightened risks attached to spread of COVID-19. And furthermore, the federal government issued guidance stating that nursing homes had acted as a catalyst for the spread of the disease to the public at large. The federal government likewise had guidance that nursing home workers had become disproportionately infected with COVID-19. All of this points to the fact that the governor had a rational reason or a substantial reason for implementing Executive Order 2020-16 to prevent the spread of COVID-19, and particularly as to the imminence of the threat, Your Honor. This court in Zucht versus King upheld the validity of a San Antonio city ordinance that required all public school children to be vaccinated. And the court upheld that ordinance despite the fact that there was no public health emergency in the city of San Antonio whatsoever. The court held that the city was allowed to protect itself from the imminent risk of spread of diseases that could be prevented through vaccination. And this case is similar. Here, the court should allow the governor to exercise her reasonable judgment, particularly in the face of all of the scientific evidence pointing to the need for these types of restrictions. The governor's decision to implement the order at large, and particularly Section 2A, was entirely reasonable. It did exactly what the science says states should do.
Mr.
The science said,
why did the governor, why did the executive order only deny exemptions to nursing homes and not other congregate care facilities that are also, you know, like for people that work in prisons or even hospitals? Aren't there also vulnerable people in those populations?
Yes, Your Honor, there are vulnerable people in those contexts. However, there's nothing in the record to show that those contexts present the same vulnerabilities that we know for a scientific fact exist in nursing homes. For instance, there's no evidence in the record to show that by and large, people who are in prisons or hospitals are above the age of 65, where science tells us heightened risks attached to spread of COVID-19. People in Hamilton Heights.
We could take judicial notice of that, though, I think.
Yes, Your Honor.
There's certainly going to be plenty of older folks in prisons and in hospitals. So what's your other reason?
Well, Your Honor, almost by definition, people in nursing homes are above that age. But additionally, there is no evidence in the record to show that the prison population or hospital population has acted as a catalyst for the spread of the disease to the public at large. There's also no evidence in the record to show that prison workers or hospital workers had become disproportionately infected with COVID-19. But we do have evidence that all of those unique vulnerabilities exist in the context of nursing homes. All the governor needs to show to uphold the validity of this order is that there was a substantial reason for doing so, and that it is not arbitrary. Here, she has done so because she had a myriad of reasons to implement Executive Order 2020-16, and those reasons were substantially related to the goal of preventing the spread of COVID-19 on the island state of Lincoln. Further, the 12th Circuit cited to the case of Smith versus Cahoon in determining that the order here was arbitrary. However, that case is entirely distinguishable. The statute in that case required for-hire shippers of certain food commodities to obtain a bond or insurance policy while not having any similar requirement for shippers of other types of food commodities. The court looked at the reason the state had implemented that order, which was to protect the public on the highways. And the court recognized that there was no reason to treat shippers of certain food commodities differently than shippers of other types of food commodities. The order was arbitrary because there was simply no reason to do so. Here, the governor had plenty of reasons to treat nursing homes more protectively than the other types of contexts that are exempted from the mask mandate. It was borne out by the scientific evidence, and she used her expertise as a trained epidemiologist to make the distinctions necessary. And turning to my third point, Your Honors, under this court's precedent, this court has routinely instructed that the state is in the best position to make decisions regarding public health and should be given due deference in those decisions. In fact, just this year, Chief Justice Roberts, in his concurring opinion in South Bay United Pentecostal Church versus Newsom, reasoned that the federal judiciary lacks the expertise necessary to make decisions regarding public health. He also stated that even if the court could make such decisions, they should refrain from doing so because they are simply not accountable to the people in the same way as the state decision makers. And that principle was not new, but came from Jacobson itself more than 115 years ago, where this court held that the safety and health of the people of a state are in the first instance for that state to protect and guard. And furthermore, under this court's precedent in Gonzalez versus Carhart, this court has continuously held that decision makers on the state level must be given especially wide latitude in the context of scientific uncertainty as to how to proceed against a particular problem.
Do you really want to rely on Gonzalez against Carhart on abortion regulations, which are surely as subject as any to pretextual legislation?
Of course, Your Honor. However, I'm not relying on that case's holding, but rather on the reasoning that state decision makers should be given more deference in the face of scientific uncertainty because they are better able to weigh the facts on the ground as they exist than this court would be able to do. This court's precedent has routinely instructed that that is the case and that state decision makers should be given deference in making public health care decisions. Your Honors, I see my time has expired. Thank you.
All right, thank you, Mr. Dernbach. Then finally, we'll, subject to rebuttal, we'll hear from Ms. Kauser.
Chief Justice, and may it please the court. My name is Lauren Kauser, and I also represent respondents Hamilton Heights. This court should affirm the 12th Circuit's decision that Ms. Smith is not entitled to protection under the Americans with Disabilities Act and dismiss the ADA claim for the following 3 reasons. First, Ms. Smith has not met her burden of demonstrating that she is both disabled and a qualified individual as defined under the Act. Second, Hamilton Heights has shown that Ms. Smith is not otherwise qualified for her position and that no reasonable accommodation is available. And third, any accommodation would impose an undue hardship on Hamilton Heights. The ADA protects qualified individuals with a disability who are able to perform the essential functions of their job with or without accommodation, unless such accommodation would impose an undue hardship on the employer. The burden is on Ms. Smith to establish a prima facie case that 1, she is disabled, 2, she is a qualified individual, and 3, that she was discriminated against because of her disability. As a threshold matter, Ms. Smith must show that she is disabled, which is defined under the Act as a mental or physical impairment which substantially limits the individual's ability to perform one of the major life activities. The 12th Circuit held as a matter of law that Ms. Smith did not meet that burden of demonstrating how she personally is substantially limited as compared to the general population.
What more do you think that she needed to do? And particularly, I just want to say that I think this court needs to be pretty sensitive to the fact that the 2008 amendments to the ADA had bipartisan majorities, large ones, telling us that we had been much, much too stingy in our interpretation of these parts of the ADA. It seems to me you're asking us to go back before the days of the 2008 amendments.
No, Your Honor, I am not asking to go back before the amendments. The 2000 ADA amendments may have lowered the bar, but there is still a bar. Congress considered and explicitly rejected the notion of removing substantially limited from the definition and affirmed that there are no per se disabilities. It is not enough to state the diagnosis and the major life activities that are impacted. The individual has the burden of showing how they personally are limited in the extent and manner to which they can perform that major life activity as compared to the general population. And here, Ms. Smith has not done that.
Do you think a jury could reasonably infer here from the fact that she wants to keep her job, but has chosen, in essence, she'd rather give it up and be fired for failing to wear a mask than put up with the consequences of her disability?
Your Honor, if we were to allow Ms. Smith to state the disability and the major life activities impacted and have a jury make a difference, we would essentially be creating a per se disability. The fact that she has claustrophobia.
No, we'd be leaving it for the jury to decide. And I'm just trying to suggest that it might be a reasonable inference that a person who is forced to choose between her job and coping with her disability, the fact that she's chosen to give up her job suggests that it's pretty darn substantially impairing her major life activities. What's unreasonable about that logic?
Your Honor, it's not that that logic is unreasonable, but it's that Ms. Smith has not provided the details necessary for the jury to weigh how she personally, when she interacts with others, when she's attempting to work, is impacted. And
your theory is that it's just she's a little vague. Is that it?
No, Your Honor. What I'm saying here is that Ms. Smith has not provided any of the necessary detail in order to make that determination. The juror must weigh whether or not she's substantially limited as compared to the general population. If she doesn't explain how she personally is limited, that assessment cannot be made. And even if this court were persuaded that Ms. Smith is disabled as defined under the ADA, she still is not entitled to protections because she has not shown that she is a qualified individual. The district court relied on this court's holding in Albertsons versus Kirkenberg that when there is a mandate by law imposing a safety qualification on an employer, the employer does not need to justify employing that safety mandate, nor do they need to provide accommodation. The employer in that case has both the right and the obligation to follow the law. And here we have a similar set of facts. The executive order mandates that Ms. Smith wear a mask while employed by the nursing home. That has been imposed on Hamilton Heights, and they have both the right and the obligation to comply with that order. To do so with
Counselor, seems like a very compelling argument for a private employer. Hamilton Heights is a state agency, right?
Correct, Your Honor.
So at some level, the governor is the boss, right?
Yes, Your Honor.
Okay, so in that case, why can't somebody like Ms. Smith pursue the theory that in essence, it's the governor who's violating the ADA by giving these orders to Hamilton Heights so that this just following orders defense is not sufficient as a matter of law under the ADA for a state employer?
Your Honor, here there's nothing to indicate that Hamilton Heights management who made this decision were engaged with the executive office of the state in making that decision.
But let's just assume that they work for the governor. Okay? Indulge me that assumption. Then what do we do?
Your Honor, in this case, the executive mandate is across the board for all nursing homes. It does not single out state-run nursing homes where the state is controlling their employees only. It is a mandate that is across the board for all nursing homes. And Hamilton Heights has the right and the obligation to comply with that order. And further, notwithstanding the executive order, Hamilton Heights of its own accord can impose this restriction as a business necessity. Here,
it has not done so, right? It's just, its defense is that we're following the governor's order. And if the ADA is about anything, it is about rejecting one-size-fits-all rules without individual consideration of particular jobs, individuals, and disabilities and how they fit together. And apparently you all refuse to talk to her about possible accommodation.
Your Honor, the protections of the ADA are not absolute, which is why they allow for affirmative defenses of both no reasonable accommodation and undue hardship, because there are cases where an employee may be disabled but could pose a risk or a threat in an accommodation.
But doesn't that require individualized assessment? And well, so go ahead.
No, Your Honor, because in this case, it is a uniformly enforced requirement across all employees and individuals that is job related and consistent with business necessity.
Well, okay, that's not how I understand the ADA, but go ahead. So,
Your Honor.
Can I ask a question? You talked about Albertsons, and does the Albertsons case apply to state law?
Your Honor, the Albertsons case isn't clear whether it would apply only to federal or to state law. The logic and reasoning that the court explained in Albertsons was that because the safety regulation in question had the force of law and was imposed upon the employer had the right and obligation to comply. Here, the executive order has the same effect on Hamilton Heights as an employer. They have both the right and the obligation to apply. And to go back to Your Honor's question earlier regarding business necessity, the ADA allows for affirmative defenses of business necessity. If the employer can show that there is a safety-based qualification standard that is uniformly enforced, job-related, and consistent with business necessity, they are justified in that order as long as no reasonable accommodation is available.
But that's circular, right? The question is, what if you can't decide about reasonable accommodations without looking into the details of the individual, her job, her conditions. And if I could follow up on my colleague's question for a moment, your defense theory certainly does seem to pose some challenging problems under the supremacy clause, right? As I think the dissent noted in the Court of Appeals, your theory would seem to allow state law to impose sweeping rules that have to be followed regardless of individual circumstances, and effectively deny a set of employees their rights under the ADA.
No, Your Honor. The law in question in Wasp versus EMA, which was discussed in Judge Canby's dissent, was specifically targeted towards the Medicare anti-lien statute. What the state had put into place was a requirement that Medicaid recipients that received tort awards pay those awards to the state in direct opposition to the anti-lien statute of Medicaid, which was targeting those individuals.
I wasn't trying to draw on the particular case he was citing. I was concerned about the more general principle. The maneuvering between state and federal governments over financing of Medicaid and trying to shift money back and forth is complex. We've dealt with it. We will continue to deal with it. It's not this case. What I'm concerned about, though, is your theory allowing a state government, in essence, to nullify the ADA by sweeping rules rather than without allowing individual assessments.
Your Honor, it's not that it's allowing it to have a sweeping rule, but here we are in an unprecedented situation. We have a pandemic that we have not seen the likes of in the past. And the state is doing the best it can to protect the population in enacting this safety measure. And even if we were to look to an individualized assessment, this court in Bragdon versus Abbott considered the direct threat analysis on an individual level. And there, the court held that great deference should be given to the medical and objective scientific evidence from public health authorities, such as the CDC. In Bragdon, however, what is distinguishable from this case is that the patient was targeted by the dentist because of her HIV. It was not a mandate that he had for all patients to receive dental treatments in hospitals. It was only this patient because of her HIV. And the reasons that he stated were that the spray from her dental treatment could spread and that the hospital was a safer environment. However, the medical evidence at that point showed that there was nothing to show that HIV could be contracted through spread or that a hospital environment would be safer than the dentist office. Here we have CDC guidance, which tells us that a face mask is the most effective means of stopping the spread of respiratory droplets, which is how COVID-19 is spread.
Can I ask you a question about reasonable accommodation here? One of the statutory forms of accommodation is transfer to another job that's vacant, right?
Yes, Your Honor.
So if we look beyond just the walls of the Hamilton Heights nursing home or veterans home, aren't there an awful lot of other jobs in the state government that become vacant now and then that Ms. Smith would be able to transfer to?
Your Honor,
Isn't that worth discussing?
Your Honor, there's nothing in the record to indicate that there would be other jobs that Ms. Smith could transfer to. However, if she is within the premises of Hamilton Heights in another position and she's not wearing a mask and she were to spread those respiratory droplets within the site and a patient were to contract COVID-19, the magnitude of that harm would outweigh any accommodation that could be reasonable. And that is why there is no accommodation for someone to not wear a mask while within the confines of the Hamilton Heights. And therefore, the going through the process would not vet any results of reasonable accommodations. And an accommodation could impose an undue hardship on Hamilton Heights. To evaluate undue hardship, we look to the financial cost, the difficulty, and the type of operation. Here, if Hamilton Heights were required to comply with the executive mandate, they would be imposed a $5,000 fine for each violation and could be subject to loss of licensure. That could effectively put Hamilton Heights out of business. In addition, if Hamilton Heights
Wait a
were—
minute. It's a state home. Would it be the state imposing the penalty on the state home?
Yes, Your Honor. If the home was not complying with the order to protect the residents, then they could lose their license. The statute does not make exceptions for the fact that it is state-owned. It would apply uniformly across all nursing homes.
Okay, I'm puzzled as to why the governor couldn't take care of all that in her order, but please, you may want to wrap up and proceed. Thank you.
Yes, Your Honor. And further, if the Hamilton Heights residents were to contract COVID-19, if Ms. Smith were offered an accommodation, that could prove a liability to the residents, as they would have to account for the fact that they did not take proper safety precautions. Also, there's the harm to the residents if they were to contract COVID-19. If residents were to leave the confines of Hamilton Heights out of fear that Ms. Smith is not following those safety precautions, it would put a vulnerable population back out into the island. And further, if they were to contract COVID-19 while on the premises, they would suffer the most severe complications, up to and including death, which would prove devastating. And because Ms. Smith has not met her burden of demonstrating that she is entitled to protection under the ADA, Your Honors, I see my time is up. Thank you.
All right, thank you all. Thanks. Let's see, sorry, I believe some time was saved for rebuttal. Who's going to be using that time?
I am, Your Honor.
Mr. Fishman, please go ahead.
May it please the court, the petitioner has 1 point on rebuttal. Your Honor, Judge Hamilton noted that Jacobson is an outdated standard here. It was announced in 1905 and allows this egregious standard to be put forth. The proposition that the respondent argues for here would essentially bar all oversight of executive actions, in this case, absent the most egregious violations of the Constitution. This cannot stand here. For these reasons, we ask this court to reverse the lower court's decision and find that Governor Whitmer's issuance of Executive Order 2020-16 was
Governor
an invalid
Wu,
exercise.
Governor Wu, not Governor Whitmer. Right?
Whitmer.
Governor Wu, Your Honor.
Thank you.
Thank you.
Okay. Our thanks to all counsel. The case is taken under advisement. And congratulations to all of you for excellent presentations. We'll be gathering virtually again in a little while. Thank you. Thanks again.
Okay, everyone, I will now move you into your breakout rooms. We will continue here momentarily.